Hi, I'm Matt Landsman, a board certified criminal defense attorney practicing here in Florida. Today, I want to talk about how Florida law treats the smell of marijuana during a police search and why two recent court decisions, uh, specifically Rosales v. State and Baxter v. State, could change the way that your rights are protected here in Florida. So, first things first, let's start with some background. Historically, in Florida, there's something called the plain smell doctrine. Now, that's been used by some law enforcement as a justification for conducting a search without a warrant. Courts have recognized the odor of marijuana as sufficient probable cause under the Fourth Amendment of the United States Constitution. This principle has been upheld in many, many cases in Florida and around the country, but specifically in Florida, and such as, and I'll give you an example of from our area in the First District Court of Appeal, Johnson v. State. It's out of the First District Court of Appeal in 2019, and I'm going to quote it, where the court said, and I quote, "Even if smoking marijuana were legal altogether, the officers would have had probable cause based on the fact that Johnson was operating a car. The possibility that a driver might be a medical marijuana user would not automatically defeat probable cause." So that's from Johnson, First District Court of Appeal, uh, in 2019. So things have changed since then. So in Florida, thanks to a few big law changes, uh, specifically, there's two key ones I'll discuss. A new law is affecting Florida search and seizure law. Now, for example, these two laws change how these two ones I'm going to mention change how Florida courts analyze marijuana and probable cause. So in Florida statutes 381.986, that allows for the medical use of marijuana in Florida. And then there's also Florida statutes 581.217. And now that regulates the hemp industry and allows for legal smokable hemp. It is no longer clear that smelling marijuana or something that smells like marijuana is always an indicator of illegal activity. So that's kind of part of what happened with those two laws that got put on the books. Now, to make matters more complicated, under Section 893.023 and 21 USC Section 802, 16B specifically, hemp has been excluded from the definition of marijuana, which will have to be in a different video, despite being visually and olfactorily all smell indistinguishable from cannabis. So they smell exactly the same. And the state in different fights, legal fights around Florida, has conceded that hemp and marijuana smell the same. So for all those kinds of those new laws and these kind of the facts about marijuana and this way it smells, that's kind of messed up how Florida has been handling probable cause and the plain smell doctrine for decades based on these cases that come out and the changing marijuana landscape. So let me explain two important Florida cases to kind of demonstrate this point. The first case is called Rosales v. State. It's out of the Third District Court of Appeal in July of 2023. Now, in Rosales, the defendant was appealing a conviction and raised a primary issue, which is, should the smell of marijuana still constitute probable cause in light of the legal medical use of marijuana in Florida? And the court said yes. The court said yes, that they can still use probable cause with the smell of marijuana from plain smell. And the court there cited Florida statute for why it's still a good search if they smell marijuana. And that was Florida statute 381.986 1K55F, which prohibited the use of medical marijuana in a vehicle with an exception for low THC cannabis not in a form for smoking. Now, the court leaned on this and prior precedent to conclude that, and I'll quote the court here, we cannot say that it would be unreasonable for an officer to conclude there is a fair probability that someone driving around smelling of marijuana is acting unlawfully. So that's what the court said from Rosales. So the third DCA affirmed the conviction and sided with law enforcement and preserved the plain smell doctrine at the time. and especially for vehicle searches. But then after that, an important case came out called Baxter, and the second case is called Baxter v. State out of the Fifth District Court of Appeal of Florida in August. Now it's just a few days later after this other decision. It's not that long between these two dates. Specifically, it was what was it? It wasn't more than months. Um, in Baxter, they took a more kind of citizen protective approach when the court was analyzing the plain smell of marijuana. And there, the court recognized what many defense attorneys around Florida have been arguing about for a long time. And they've been arguing that the smell of marijuana is no longer clearly indicative of criminal activity. And there, the court ruled, and I'm going to quote the Baxter court: the plain smell of marijuana is no longer clearly indicative of criminal activity, and it alone cannot provide reasonable suspicion to support an investigatory detention. Now, that's a really major shift in Florida. It happened recently. And although Baxter's conviction ultimately was upheld, which is kind of messed up, but it got upheld due to the good faith exception. And there was other issues in the case for why maybe it also could have been reversed, but the court didn't address those. So they're saying that at the time, it's a good faith exception means that even though they're kind of going back on this existing precedent, or they're trying to have new factual circumstances in Florida, are now kind of changing the law about how the law the officers can rely on. They're saying, well, no, the officer could rely on prior court interpretations at the time of the stop. So therefore, this guy's conviction got upheld. The opinion itself is now binding in the Fifth District Court of Appeal. And that means that future traffic stops and searches based solely on smell may be ruled unconstitutional in that jurisdiction. And there's other jurisdictions that are going to feel the same way. But in the Fifth DCA, it's clearly controlling. So what does that all mean? Like discussing these two cases and what's happening. It means that if you're in Miami-Dade, Rosales is going to be the more important case to know about. And they're going to talk about that the smell alone may still justify a search if you're in Duval or Orange County. But under Baxter, officers are going to need more than just a smell to stop and search you, because they're going to be more concerned with the Baxter court. And of course, both of those have to do with smell alone. So there's also some more recent cases where the courts are trying to distinguish between when is it smell alone, like some circumstances where they're saying, well, there's this plus another factor, therefore it's not using the smell alone analysis anymore, and they'll come up with other reasons why. But this concept is about smell alone. And now this disparity between these districts is exactly why your attorney's knowledge of local precedents. So it's not just Florida. Like Florida has this huge legal structure, but it's also broken down by a district court of appeal and then local courts within trial courts within each district. So if you've been charged with a crime, especially one involving marijuana, drugs, or a search and seizure, you need to ask some important questions. You need to ask, was there a search? You need to know, was it based on smell? You need to know what district you're in. And you need to know, did the officer rely on outdated assumptions about probable cause when he conducted any sort of search or seizure in your case? So that's kind of questions you need to ask yourself. Now, the law is changing fast in this area, and what might have been accepted yesterday can be unconstitutional the next. So it's very concerning. If you've been arrested, your case could depend on how well your attorney knows the law. And I can't stress how important it is that you have an extremely knowledgeable lawyer on your side. I hope this video has been helpful. If you are in legal trouble, call me, Matt Landsman, Landsman Law, for you.